Last year, the Supreme Court of Canada struck down the sentence of life without the possibility of parole, calling it cruel and unusual punishment. The court called it incompatible with human dignity to keep someone in prison with no hope of release. But does the justice system do enough to make such murderers, sometimes mass murderers, suitable to return to life on the outside? With us now on that, we're joined by Lee Chapelle. He is president of Canadian Prison Consulting, Inc. Kalish, executive director at Victim Services Toronto, and Anamaria Enenajor, partner at Ruby Shiller Enenajor DiGiuseppe, Barristers. Great to have everybody here in our studio for this timely and important discussion. We found out it was last year that the court made the big change in how things proceeded. Why did the Supreme Court make the decision it did?
Because the law as it was drafted was a bad law that gave judges little options, and the only remedy was to strike it down. And the striking down of that law as unconstitutional is actually quite narrow. What the Supreme Court of Canada said through its decision is that a judge cannot impose a sentence on an individual that guarantees that they will die in prison. All other options are open, and so where the Supreme Court of Canada doesn't make a pronouncement, and in fact it expressly endorses a sentence, is that there's a sentence of life in prison, which is what everybody who's been convicted of first-degree murder must have imposed on them.
Let me do one more follow-up with you, again, to get some background on this for our discussion. The Supreme Court also made significant rulings on so-called mandatory minimums. What's the change there?
So there's some of the laws that the Supreme Court of Canada struck down were already repealed by the Liberal government, and some of them that the Supreme Court of Canada upheld also have been repealed by the Liberal government. Essentially what the Supreme Court of Canada does by striking down a piece of legislation being a mandatory minimum is saying that it is unconstitutional because it robs the judge at trial, the sentencing judge, from the ability to craft a proportionate and fit sentence taking all factors into account. There are so many various scenarios which can result in a person being convicted of an offense, and in order to take into consideration the breadth and diversity of those experiences and way that those crimes are committed, it is important for judges at sentencing to have the flexibility to impose a sentence that they deem is fit and proportionate.
Okay. We have two other guests here who, of course, represent the differing sides of this debate. And Lee, let me start with you. Tell us what the effect on a prisoner is who has been handed a life sentence.
The effect on a prisoner who has been handed a life sentence, right?
The effect, the emotional and mental effect on them.
Well, okay, and I'll get into that, Steve. I'd like to say that life is life, just to make that really clear. Whether the ineligibility date is 25, 40, 50, 75, 10, a life sentence is for the duration of a person's life, and there's no guarantee of parole. So just as a follow-up to that, as for the mindset, it varies. I mean, it's nuanced. So there are a lot of offenders who are first-time offenders, believe it or not. Life can often be a first-time offense, emotionally charged, something that just came up and happened. And I'll tell you, there's a lot of lifers that I've worked with and met who absolutely wish they could go back and change 10 seconds, a minute of that day. And do not feel good about what they did. And this is not about getting parole. This is just a genuine feeling. On the flip side of that, you have people who are entrenched in subculture and organized crime, gangs, where it can be a notch on the belt and a different impact for that person. And I think it's important to note that the high majority of times when a person receives a life sentence, they've generally drawn 3 to 4 years incarceration, in custody already in a provincial detention center. So by the time they're sentenced, they become fairly accustomed to being incarcerated at that point. Dependent upon the eligibility date, that's where you're looking at whether there would be light at the end of the tunnel for this person to do the work and try to work their way back out or not.
All right, let's go to Carly to get the other side of the coin. We just heard Lee say whether it's 25 years, 40 years, or 10 years, life is life. Do you agree with that?
I mean, it's so nuanced, right? There are victims and survivors who, believe people can be rehabilitated, and they want to hear how someone is changing and growing and working towards, being a rehabilitated person. And then there are some victims and survivors who would be appalled, that they would get even the chance of being released or free to live in society a day earlier. Right, and what I think is also missing from the conversation is the general community, the safety of community and how they're feeling. So it's not just victim in a singular sense, but victim in terms of everyone who is impacted in terms of community safety, and that needs to be a considering factor as well.
The maximum sentence now is 25 years. Is that life to you?
No.
So we must
But
correct
Steve,
that.
that's inaccurate.
Okay.
The maximum sentence is life in prison.
Right.
There is an eligibility of parole that was at issue with the Supreme Court of Canada's decision. Okay. Once a person gets to 25 years serving a life sentence, then they may be eligible for parole at that point in time.
But it's not a slam dunk that they'll get out.
It's not, and the Parole Board of Canada is extremely risk averse. They take a consideration of the factors of the offense, the programming that the individual undertook in custody, and are really focusing on whether or not that person poses a continued risk to society. And it is an uphill battle for anybody, especially someone like Mr. Bissonnette in the Supreme Court of Canada case, who was sentenced to for multiple murders, to make the case that they should be released after 25 years. Mm-hmm. It is incredibly difficult for them to be released after 25 years. And in fact, if we look at the number of people that are convicted convicted and are serving indeterminate sentences, so dangerous offenders, as well as those convicted of first-degree murder, there are approximately 4,000 of those released every year. Of those 4,000, so these are first-degree murder or multiple murders. Of those 4,000, 5 of them have committed, who are released on parole, have committed violent offenses. So the rate of recidivism is extremely low compared to the number of violent crimes that are committed in Canada overall, about 187,000 a year, violent crimes. Of those, only 5% are people who are released on parole after having served 25 years or are under an indeterminate sentence.
All right, well, let's try that. Bissonnette, of course, is the guy who went into the mosque in Quebec and, committed one of the worst mass killings in Canadian history. There will be people watching us right now who will say, Lee, that guy should never get out and should never even have the possibility of getting out. What would you say to them?
Well, I think the two comments are not entirely related about should not get out and should not have the possibility of getting out. Again, to follow up on this point, parole is a privilege at the best of times. Mm-hmm. It's not easy to attain, and I know from personal experience, I can point to dozens of lifers that I am familiar with that I knew from my old life, who are now 30, 40 years in on life 7, on life 10, and never had a parole. Many have died in palliative care. Pete Collins comes to mind, a gentleman from Ottawa who spent 32 years in prison for killing a police officer in Ottawa. He had bladder cancer and metastasis and posed no risk at all and was unable to achieve a compassionate release to die on the street. Now, rightly or wrongly, that just reinforces, I think, the fact that our system is not soft, nor is it letting lifers out en masse, and it's not easy to do. So, yes, there's a very high threshold, there's a very high criteria.
Out of curiosity, did he ever show any remorse for his crime?
He did, very openly and very publicly, and he helped a lot of people while he was inside. He acknowledged, he owned it fully, and he was aware he had taken a life and there was no way that he could ever get that life back.
But let me just check with Carly here. Is it your view that if you get a life sentence, it should be your entire life, period, full stop?
I think it's too complicated to just say yes or no, right? Okay. Like you look at those 8 girls who were just charged or with murder, right? And it wasn't first degree. But they're, some of them are 13 and 14 years old, right? Like, and I don't think they're going to get a life sentence, but it's quite nuanced. And I would want, from a social work perspective, I'd want to understand what led somebody to do that. What is the likelihood that they would, commit a crime again? There are too many factors to just determine yes or no. But I will tell you, from a victim and survivor perspective, every time there's a parole hearing, every time you're at, you have the trauma of what occurred to you. You have the trauma of going through the criminal justice system, and then you have the trauma every time something like this presents itself. And so that should also just be considered. It should be consideration in all of these things is, the individual and the community impact, right? Every 2 days, a woman in Canada is murdered. And
say that again?
Yes,
wow.
Every 2 days in Canada, a woman is murdered. And we're not looking at it from this bigger perspective of violence against women, gender-based violence, and mostly it's by an intimate partner, right? And so every time that happens, women in general are scared, right? Like, that's a terrifying thing to think about. And so it's really understanding that the community impact of a crime, in addition to that terrible atrocity that happened in her family and everyone else who was personally impacted. And so there's I just think it's so complicated.
It
right?
is. But all right, let's try this. Yeah. Anamaria, do longer sentences have a deterrent on crime?
No, they do not.
How do we know that?
Because we've had social science evidence that has been, social science research that has been undertaken to demonstrate or to assess whether or not the length of the sentence has any relationship with recidivism. And in fact, recent studies show that the longer the sentence, like a longer sentence, actually supports recidivism by 3%. So the longer a person is in custody, the more likely they are to rescind and to commit a crime once they are out of prison. So
because prison life is so inhumane, it's harder to.
There's a multitude of factors.
Okay.
And a lot of it is about separation from society in such a way that doesn't permit them to understand how to reintegrate appropriately and takes them away from legitimate forms of making income. There are all of these factors that should be taken into consideration. Also, when an individual is in custody, they lose ties with their family and with their loved ones, and that is a huge factor that goes into determining whether or not a person will commit a crime again. So it is, in fact, these studies have shown that it is the certainty of conviction rather than the length of a sentence that deters crime ultimately.
Lee, I once heard, I think it was George Will, the American newspaper columnist George Will, who once said the one thing that ought to be, above all else, considered when we're having these discussions are two words: sentences end. And because sentences end, we've got to figure out what to do with these folks.
What next?
When an attempt to reintegrate them into society happens. So let's follow up on the last area of conversation. How would you characterize the criminal justice system's current success rate at so-called rehabilitation?
Well, it is nuanced. There's no question about it. I'd almost like to see a hybrid model of corrections.
Which means what?
I'm a firm believer that we have approximately 80% of inmates in Canada today who are very open to and want to change. I also believe we have roughly a 20% demographic who are locked into a world of subculture and crime and don't want to change.
So we need to focus on the 80?
I think that the detriment of the 20, we need to find a way somehow for that not to influence the others. I mean, in a simple, I don't know if my math is right, it's an estimate, but certainly it's a challenge. Amber, you referenced the importance of community supports, and it's so true. That support, we've also got so many prisoners that are coming from child welfare backgrounds who have no community supports, and that's a big part of what led them to where they are today, sociological factors. Having said the sociological factor part, I'm still a firm believer in personal responsibility, And regardless of what you've been through, you need to come to a point in your life where you are responsible for your actions. And you
Okay, let me get Carly on the other side. Do people who represent victims in this debate believe rehabilitation is possible?
You know, I think we have to invest in rehabilitation. Do I think it's possible? Yes. But is our system investing in that? Not enough, right? And so, I mean, as a trauma therapist, rule number one for engaging with a client is, are you ready? Are you open to making change, right? So you're saying 80%
Very
is
much.
Great. So, right, you have to engage with people who are ready to engage in that reflective work, right?
Does that number sound right to you, that 80% of people behind bars?
I wouldn't know
I
wouldn't know the answer. I'm hopeful that's the answer, but I can't speak to it. And you know, we also have to. The elephant in the room is in the social reckoning that we're all going through is the disproportionality of who is in jails, right? And before we can really do work to change, to change the laws 25 to 40 years, to me it's a little bit moot, right? The conversation is what are we doing, disproportionality in terms of kids who are accessing the child welfare system, disproportionality for adults who are in the criminal justice system, and what sort of supports are we investing in rehabilitation if they're going to get out earlier, what is changing in terms of the treatment they're receiving, both inside and outside. And we know our social service system outside of prisons is already at full capacity. There's no shelter beds. There are very long waiting lists for resources for mental health supports. And so until we address those issues, how are people being rehabilitated inside, and then what's going to happen to them outside?
Well, let's pick up on that.
Same is true inside.
We know where things are at with rehab right now. We also know that society, I don't know if revenge is the right word, but society wants its punishment for people who commit crimes. What goes first, what goes second? Where do we put the accent, rehab or punishment?
Well, it really depends on the case. The fundamental principle of sentencing in the Canadian justice system is proportionality and individualization. Proportionality being the most fundamental. Proportionality means that when a judge is assessing how much of a sentence, how long a sentence, or the nature of the sentence to give an individual, that they have to take into consideration the gravity of the offense as well as the moral blameworthiness or culpability of the offender. And in balancing those two aspects, those two principles, they can draw on a number of principles that animate their sentence. Things like deterrence, denunciation, rehabilitation, and other principles that are escaping me now. But primarily what the court is focused on doing is making sure that a sentence is not more punitive than it should be or less punitive than it should be.
Do you think victims are more on the side of understanding and forgiving and wanting rehabilitation, or more on the side of vengeance?
It's not about vengeance per se.
Okay, that's a bad word. How about?
You think of like someone like Paul Bernardo, right? Like you hope he never gets to never gets to be released ever. And then there are people like those 8 girls that I was mentioning before, where you're like, I really want to understand what led them to do this. I hope they get a chance to rebuild on their life, right? And it doesn't mean it's less horrific what they did to that man, but there's just, you really want to understand why someone did it, and really get a chance to articulate how it impacted you. And so, yes, there are tons of victims who would say, lock them up, I don't care what happens to them, they should never see the light of day again. And you get it, right? After their life has been fundamentally changed and impacted.
But based on what you see, is rehabilitation genuinely possible?
Yep, and on the flip side of that, Steve, just for a moment, the families and loved ones of offenders, especially, the first-time offenders that I predominantly work with, also are just absolutely appalled with the system and the lack of help and resource and that sort of thing. So there's unhappiness. I think it's a wedge issue that I think we could talk about this annually for the next 20 years and likely not be too much further ahead. I hope I'm wrong, but
you know people. You know this world. Do you think rehab is possible?
I do. I believe
You've seen it.
I do. would like to think that, I hit a point where I understood being born to the care, custody, and control of the child, the CAS, and foster care, and all the things that I went through as a young person, was something that I had to hit a point where I had acceptance and forgiveness and realized that I was just damaging myself the further and further I went with justifying my actions from what was I felt a very unfair beginning. And I think this is true for so many today. And I think one of the key elements I do with the clients I work with is keep the focus on what brought you to prison, first and foremost. Really focus on that instead of picking apart the system and where it's lacking, because if you start feeling victimized, the odds of coming out and never returning lower. If you can own it and you realize and work on your insight, and that focus has to be really, really paramount.
Anamaria.
And I think we have to understand what we're talking about when we're thinking about the principle of rehabilitation that judges take into consideration when handing down a sentence. What they are doing is that they are acknowledging that an individual can change in the future, and they're using that to craft an appropriate sentence based on that possibility and that hope. What a judge isn't doing is prescribing a rehabilitative program for that individual when they are in custody. They're not guaranteeing a rehabilitative custodial experience. And so we have to divide what the Supreme Court of Canada in Bissonnette is doing, which is discussing the severity of the sentence based on its length, with the administration of a sentence. We have to distinguish those two things. The administration of a sentence, the programming that's available, and the preparation for an individual that is available once they leave custody, that is up to the prisons themselves, and that is up to the parole board. That is an administrative decision. When our courts are handing down sentences, all they do is consider whether this person in front of me, usually if it's a young person, that rehabilitative potential will be far more paramount in their mind as a principle to consider. Whether that person we should take into consideration rehabilitation for that person. They are not prescribing a rehabilitative experience. They are not permitted to do so.
Let me find the other alternative here. We're sadly down to our last minute here. Time has flown by. Carly, restorative justice, is that an option that should be pursued more often?
I think it's an option. It's not a solution, right? You have to, the person accused has to be willing to own up and be ready to change and talk about all of those things. I think that, survivors and victims should have the option of going through that, but it doesn't, it's not the one-size-fits-all solution to the criminal justice system that,
Quick word on that, Lee?
It can be very effective, and I look at one of the earliest forms thereof, and that's the healing circles with Indigenous people. And the reason it was effective was it was a homogeneous makeup, shared community, shared. When you lose traction on that, it becomes much harder to facilitate effectively. But it's very helpful we have a system that pits offender against victim and vice versa. So if there was an ability to understand more directly as to the impact to the victim and what led the offender to what they did, it can often be healing. And I know it takes a lot for somebody to want to sign up for that, but I do believe there's some really good merit and benefits if able to do.
Okay, I feel like we have only begun the discussion here, and we need to have the three of you back to continue it. But until that happens, I do want to thank Carly Kalish from Victim Services Toronto, Lee Chapelle, President, Canadian Prison Consulting, Inc., and Anamaria Enenajor, partner at Ruby Shiller Enenajor DiGiuseppe, the Barristers. Thanks all.
The Agenda with Steve Paikin is made possible through generous philanthropic contributions from viewers like you. Thank you for supporting TVO's journalism.